Hello, my name is Melissa Worth and I am a solicitor helping businesses and individuals to resolve their commercial disputes. Each week I am looking at and vlogging about a recent case, and this week I have chosen the case of Kew Holdings Ltd and Donald Insall, which was handed down on the 28th of October 2020 in the Technology and Construction Court. Failure to comply with a court order can have catastrophic consequences, and one of the tools available to a party to litigation, if the other party is continuing to fail to comply with a court order, is to apply for an unless order. This case concerned the defendant's, Donald's, application for an unless order. Donald is a firm of architects and they had been retained by Kew to refurbish a property. There was a dispute about unpaid fees, and Donald got an award of £200,000 at an adjudication, but Kew failed to settle the award. Donald therefore sought enforcement of the award and applied to court for summary judgment. Judgment was given in Donald's favour in February 2019. However, the judgment was not enough to elicit payment from Kew, and so Donald had to apply to court for a charging order and then commence proceedings for an order for sale of the subject property. In March 2020, Kew commenced a claim against Donald alleging professional negligence and seeking damages of £2 million. Kew alleged, amongst other things, that Donald had overcharged for their work and had produced inadequate drawings. As Kew had not complied with the February 2019 order, Donald applied to court to have the negligence claim struck out. The court had no difficulty in determining that Kew's conduct had been unreasonable, but nevertheless, at that stage, the court held that to strike out the negligence claim would be draconian. Instead, the court stayed the negligence claim, and the stay would be lifted once Kew had settled the adjudication award. The court also ordered that Kew must give security for Donald's cost in the sum of £600,000. The court will make an order for security for costs when it is satisfied that a corporate claimant may not be able to satisfy an order to pay the defendant's costs if ordered to do so. Kew failed to make payment of the £600,000 and was therefore in breach of the order to pay security for costs. Kew also failed to make payment of the other sums ordered by the court. The judgment considered CPR 3.1 subsection 3, which provides that when the court makes an order, it may make it subject to conditions, including a condition to pay a sum of money into court, and specify the consequences of failure to comply with the order or condition. The court also referred to guidelines that had been set down in the case of Gold Trail Travel and Iron in 2017. These guidelines included that a condition must not have the effect of stifling a party's continued participation in proceedings. In order to prove the stifling effect, the party must establish that he does not have the means to comply with the condition. The court will be concerned with the underlying realities of a company's financial position and not necessarily the assertions of the company, its owners, or its majority shareholders' views. The court will also be concerned with whether the company itself can raise some money as opposed to its shareholders. The shareholders and the company's distinct legal personality must be respected. Kew had produced witness evidence which stated it was actively seeking funds to comply with the court orders, and the court accepted that some efforts had been made by Kew, but stated that it was too little too late. Kew's breaches of the court orders were significant, and the judgment debt was over 18 months old. Kew had been afforded years to satisfy the debt. In the circumstances, it was appropriate to make an unless order. If payment of £600,000 was not made by the 30th of November 2020 as security for the defendant's costs, the negligence claim would be struck out. This case gives useful guidance to solicitors about the granting of unless orders. It also raises some questions about tactics. I don't know why Kew waited so long to advance its claim for professional negligence, but it could have been more advantageous to Kew to have issued its claim before the adjudication award was given, or as soon as possible thereafter. For parties to litigation generally, this case serves as a reminder that the court will not tolerate continued failure to comply with its directions and orders. If you have any questions about this case, please do get in touch. Thank you.